Of all the Chief Justices, John Marshall is called the Great Chief Justice. Is that warranted?
I think it's definitely warranted. He was the fourth Chief Justice. Nobody remembers the work of the first three. And before he assumed that position, it wasn't thought that the Supreme Court was a particularly important or powerful institution, or that the position of Chief Justice was a very important or powerful institution. But 34 years later, when John Marshall finished, there was no doubt about either of those things. He really built the Supreme Court into the institution that it became, or rather, he provided the foundation on which everything that has been built since then rests. So he definitely deserves that title.
We're focusing on 8 of his cases: Marbury, the Burr trial, Dartmouth, McCulloch, Gibbons, the Antelope, and the 2 Cherokee cases. Which of those cases is your favorite?
It's hard to make a choice because he did such important work, such groundbreaking work in so many areas. But I would have to say, definitely for me, it would be Marbury, because Marbury is the case that cemented the institution of judicial review or constitutional review in the United States. Marshall didn't invent it, and he didn't invent the arguments that he used to justify it. But Marbury was the case that settled its position in the jurisprudence of the Supreme Court. And I would have to say that judicial review, the power of unelected judges to review the constitutionality of laws enacted by the elected representatives of the people, and if necessary, hold that they are unconstitutional and therefore unenforceable, is the greatest American contribution to jurisprudence. It was for a long time pretty much a unique American institution. It was disdained in almost all of the other democracies of the world, certainly in the United Kingdom, in France, in the civil law countries that followed the French example. It was seen as undemocratic and as not proper in a democracy or a republic until after the Second World War. And after the Second World War, this idea spread, and now it has won acceptance throughout the world, everywhere in Europe except for the United Kingdom and I believe the Netherlands, maybe a few other exceptions, and in many other parts of the world. It's become enormously important and is seen as enormously important in protecting individual rights. So Marbury was the start of all that, and I think Marshall would be quite astounded to see where this idea has gone.
If you could talk to Marshall about any of those cases, which one would it be?
Well, again, it would be Marbury because of its importance in establishing this idea of constitutional review. And what I would like to ask him is what he thinks of this doctrine in the 21st, now that he can see in the 21st century how it has developed. Did he have any idea about how important it would become, about how much it would grow, how powerful it would be, and did he have any misgivings about how much it has grown and whether there is a need to establish limits on it to prevent it from usurping too much authority in a democracy.
Marshall's tenure spanned the era of good feelings, but there are also a lot of bad feelings when he was Chief Justice. The Jefferson administration, the War of 1812, the Jackson administration. How did he think the Supreme Court should respond to such poisonous politics?
Well, I'm not a Marshall scholar, and I certainly don't know as much about him as you do or other experts on Marshall. But my impression is that he did two things, the most important of which was that he decided the important cases that came before him in accordance with principles that he believed to be correct. He did not compromise in his interpretation of the Constitution or other laws for the purpose of meeting some political problem of the day or protecting the court from political attacks. I don't think he compromised in that way. At the same time, I think he did not go out of the way to bring the court into conflict with other political actors, particularly those that were much more powerful than the court at that time. So he was not, it was not a case of just going straight forward without giving any thought to the context in which the decision was going to be made. But when it actually came down to the interpretation of the Constitution, I don't think he ever varied, he ever wavered from what he believed the Constitution really meant. And he had strong ideas about that.
One of Marshall's colleagues on the court, one of the first Jefferson appointees, Brockles Livingston, shot and killed a man 4 years before he got on the court. Now, if you had done that 4 years before your confirmation hearing, do you think it would have gone differently?
Yes, that would be that would be something of an understatement. It's really very funny because there was, during my confirmation period, there was a fellow at the White House who was in charge of sort of the public relations aspect of this effort, which tells you something about what has happened to the whole confirmation process. And he was very supportive, and whenever anything unfavorable came up during this period, which was like a 3 or 4 month period, he would always say, "Don't worry about it, don't worry about it. I've got your back, we've got your back." And so I had this fantasy in my mind of coming in one day and saying, "Listen, I should have told you this a while ago, but I actually did murder somebody." And I had this fantasy of his saying, "Don't worry about it, we've got your back." However, I don't think it would have gone over very well.
So are our confirmation hearings so contentious now? Is that in any way traceable to the prestige that Marshall conferred on the court?
Well, it is. Of course, things have developed a lot since Marshall's day, but he provided the foundation for the things that happened later. He established, as I was mentioning, the power of a judicial review. Of course, he exercised it exactly once in relation to an act of Congress in Marbury, and the effect and what he held was that the court itself would not entertain a jurisdiction that had been conferred on the court by statute, but that he found to be contrary to the Constitution. So this was not an extremely aggressive use of judicial review. It has been used much more in ways that it was used after his tenure in a way and in ways that were much more important. So everything has developed much further than where he left it, but he provided the foundation for all of that. So the court has become an institution that decides many very important issues, some issues that I think we should not be deciding, others that we have an obligation to decide. But because people now see, senators and others see how many important issues we decide and the importance of our work, that naturally makes the confirmation process much more contentious than it would otherwise have been.
The second prominent case of judicial review was Dred Scott. How do you think Marshall would have decided that case?
Well, that's a fascinating question. And again, I have to say I'm not a scholar of Marshall or of that era. The contrast between what was done in Marbury and what was done in Dred Scott is enormous. As I mentioned, in Marbury, the court was deciding really a narrow jurisdictional question. In Dred Scott, the court was attempting to resolve the slavery issue that was on the verge of tearing the country apart when Dred Scott was decided. And of course, Dred Scott did not avert the crisis as Chief Justice Taney, who wrote the opinion, hoped. If anything, it exacerbated the problem. So what would Marshall have done? I think his jurisprudence would have led him to dissent in Dred Scott if the majority, if he had not been able to persuade the majority. I don't see Marshall saying, as Taney held in Dred Scott, that Congress lacked the authority under the Constitution to prohibit slavery in the territories. Marshall, in fact, had written some decisions saying that Congress had plenary authority to regulate the territories. So I think that he would not have gone along with that. On the issue of whether Dred Scott could be a citizen, which was the jurisdictional question in Dred Scott, I doubt that Marshall would have taken the position that Taney took, that a descendant, an African American who was a descendant, who was a slave, and whose ancestors were slaves, could never be a citizen of the United States. Marshall's views on race were not admirable by 21st century standards or 20th century standards, but they were not hard. They were not the hard views about race and slavery that I think Taney had, and that had become prevalent in the South by the beginning of the Civil War.
Marshall's only prior judicial post before he became Chief Justice was being a judge advocate in the Continental Army, and his only legal education was a few months at William and Mary under George Wythe. Do you think we spend too much attention on credentials today?
I think we do. We put an awful lot of emphasis on formal education and on degrees. Marshall had a powerful judicial mind, a powerful legal mind, a great knowledge of the law, and yet he was able to acquire it with, as you mentioned, very little formal education. Most of what he knew, I think he developed in practice. So I do think we've put an awful lot of emphasis on credentials. Maybe that's inevitable in a meritocracy. But it's interesting that I think the president, who had the deepest understanding of the Constitution, was Lincoln, who had virtually no formal education. And the president who I think perhaps had the most flawed understanding of the Constitution was Woodrow Wilson, who is the only president to have a PhD. So that might say something. If we look at the court's decision in Plessy versus Ferguson, the majority opinion, the opinion of the court, was, I use this to tease my fellow Yale Law School alumni and Harvard alumni. The majority opinion in Plessy was written by Henry Brown, who is the only justice to attend both Harvard and Yale Law Schools. And the dissent was written by the first Justice Harlan, who was viewed by his colleagues as sort of a rube. So it might tell you something.
Marshall was famous for his ability to bring people together. He did it during the Revolution as a young officer. He certainly did it on the Supreme Court. Does that spirit of camaraderie persist today?
I think it's important, and I think it makes life here more pleasant, and I think it helps our work. That we are very cordial with each other. We're friendly. In my 14 plus years here, nobody has ever said anything that was personally offensive or irritating. And that despite the fact that we are deciding questions that we care about very deeply, that we think are important to the country, and sometimes we are sharply divided on those questions. So my colleagues may think that what I want to do in a particular case is damaging to the Constitution and to the country, and I may feel that way about what they want to do, but I have never felt that my colleagues were ever doing anything other than what they think is right, and it serves no purpose for there to be personal animosity. We can debate legal issues strenuously, and we do that, and if anybody reads our opinions, you can see that there are no holds barred in a lot of our opinions, but all that can be done in a civil manner.
What do you think the essential difference is between a justice and a chief justice?
It's less than a lot of people on the outside think, and I think Marshall is perhaps responsible for creating expectations about the position of Chief Justice. The Chief Justice is not like the President, who has enormous power under the Constitution and under the laws. Chief Justice is not like the CEO of a company or an organization who has a lot of power by virtue of law. The Chief Justice has no special power over the other justices under the Constitution or by statute. By tradition, the Chief Justice has a few prerogatives. He presides at the oral arguments. He speaks first at the conference, which may be an advantage or a disadvantage. And the most important prerogative he has by tradition is that of assigning opinions if he's in the majority, but that's it. So beyond that, the Chief Justice can lead, as Marshall did, only by virtue of his intellect and his vision and his character and his personality. And Marshall did all of those things. So if anyone assumes that Marshall was able to do what he did for 34 years because he was named as the Chief Justice, that's a mistake. He was able to do those things mostly because he was who he was, because of the kind of person that he was.
Did he also have political skills with a small p, small group political skills?
I'm sure he did. I'm sure he did. The relations among judges on a multi-member court are complex, and Marshall's ability to achieve the degree of unanimity that existed for a lot of his tenure is remarkable. Now, it may be attributable to the fact that all the justices in those days lived together when they were in Washington and in the same boarding house, so they spent a lot of time together, and they had the opportunity to engage in probably more frequent discussion about cases than became possible later on, and certainly than is possible today. So they lived together. They drank a lot of wine together that Marshall supplied, but I think it was his personality. He was as you mentioned, a cheerful, optimistic person that people like to be with.
Did Marshall think he was interpreting a living constitution?
It depends on how you define that term. The idea of a living constitution is something that was developed by Wilson and the progressives. It's a clever metaphor. It's an attractive metaphor. Who wants a dead constitution? But what they understood by that term was a constitution that changes, a constitution that means something different today, fundamentally different today than it did when it was adopted or at some other point in the past. I don't think that's what Marshall I think he thought that the Constitution doesn't decide every question, that it leaves a lot of questions to be decided by Congress and by the president. It leaves a lot of things to the states, and it necessarily speaks in general terms, and those terms have to be applied to new situations that often could not have been anticipated at the time that it was adopted. But I think he had a very strong belief about what the Constitution means. He was close enough to the founding era to have a feeling that he understood the essence of the Constitution, and I don't think he would endorse the idea that it could depart from the fundamental idea that it had at the beginning.
Where do you think John Marshall erred?
Well, the weakness in Marshall's decisions, and this has been pointed out properly by modern scholars, I think is on the issue of race. His decisions involving Indians and African Americans are not what we would hope for today. But he was, although I think he was a visionary, he was a human being, he was a person of his time and his place.
Do you have a favorite story about John Marshall?
I do. This is not, this doesn't go to his most important characteristics, but I found it amusing. A number of years ago, I gave a little talk about Supreme Court justices who had athletic ability. And I asked our wonderful library to do some research for me. And what they found, I think not surprisingly, is that with the exception of Byron White, who was the most valuable player in the National Football League while he was attending law school, and so he's in a category, an athletic category of his own. But with that exception, I think Marshall was the greatest athlete to sit on the Supreme Court. In Beveridge's biography of Marshall, he recounts the fact that Marshall was a very fast runner, and so during the Revolution, when the Army was, the Continental Army was in camp, Marshall would race the other officers. His mother darned socks or knit socks, whatever you do to make socks for him, and sent them to him. And they were white socks, and he would often run against the other officers wearing these white socks, and he was called Silver Toes or Silverfoot. But he was a very fast runner. He was also a very good jumper, so he would have two soldiers put a board on their head and supposedly would jump over this. He was he remained a very robust man into his 70s.
What qualities of Marshall's are most important for us to emulate today, both for judges and for the American people?
Well, he is one of a kind, so in that sense, I don't think he can be imitated. But I would mention two things. The first, for judges, is his legal craftsmanship and his scholarship. He had a very powerful legal mind, and he analyzed questions thoroughly, analyzed constitutional questions based on the text of the Constitution and the structure of the Constitution, the history that led to the adoption of the Constitution, legal scholarship, Blackstone, Cook, precedent. He didn't have very much constitutional precedent to deal with when he started, but certainly there was a lot of case law in other areas. So he was a great legal craftsman. That would be the first thing that all judges ought to try to emulate. The second, and this would go for judges, but I think for a bigger audience, is his patriotism, his deep love for the Constitution and for the nation that adopted the Constitution and the nation that the Constitution was designed to foster. And his vision of our country as a united entity, as the United States, as a, this is important at a time, I think, of bitter, sometimes bitter division of, he had a vision of this united country that would be a great country and also a good country, and not just a confederation of warring entities. The one thing I would tell people who don't know a lot about John Marshall is that he really is the person who laid the foundation for the Supreme Court. Who knows what the Supreme Court would have become if there had not been a John Marshall. The first three Chief Justices regarded the position as relatively insignificant, and the justices, the associate justices, felt the same way. The court was not viewed as a particularly important institution. And who knows if the fourth Chief Justice had been in the same line and had served for a short period of time, and the same was true of the fifth and the sixth and the seventh, who knows what would have happened. So he was pivotal. He really did lay the foundation for what has become the Supreme Court. When he started, it was not regarded as an important institution. When he left, there was no doubt that it was an important institution.